Good afternoon. I am Viola Crawford, and on behalf of the League of Women Voters of Central Delaware County and the NAACP Media Branch, welcome and thank you for joining us today for our expert-led panel discussion on a two-part webinar program. Today, part one is pre-trial pitfalls, how citizens can get caught up in the system, and part two is scheduled for June the 16th. And many thanks to our Civic Education Committee members for organizing this program today. And many thanks to our presenters and panel moderator, Lee Awbrey from the Delco Public Defender's Office. Lee Awbrey is First Assistant to the Delaware County Public Defender and the former Chief of Appeals in the Montgomery County Office of the Public Defender. In those capacities, Lee has advocated extensively to address causal factors leading to modern debtor prisons and to fight improper pretrial detention practices that disproportionately jail poor and marginalized people. Her legal career includes a stint as staff attorney with the Public Interest Law Center, one of the organizations representing the League of Women Voters and others in their education equity lawsuit. A graduate of the UC Berkeley School of Law, she is now rooted in Delco's Bureau of Rutledge, a town known to just a few but loved by many. Lee will introduce our expert panel speakers. We are also most grateful for the help of Kathy Youngman for her technology, support, and recording of the program. The mission of the League of Women Voters, a nonpartisan civic organization, encourages informed and active participation in citizenship, elections, and democracy, and works to increase understanding about major public policy issues through education. We received many of your excellent questions prior, and these were shared with Lee. Please utilize the chat function and ask any additional questions. Also, we are recording this event, and a link to the recording will be sent to those that registered. The recorded program will also be available on our website at LWV-CDC.org. At the end of the program, I will share what will be introduced during part two. Lee, take it away.
Well, thank you so much for that wonderful introduction. And again, thank you to the League of Women Voters for providing this excellent forum for us all to engage in a conversation about criminal systems here in Delaware County and to talk about the issue of pretrial pitfalls. I want to take a moment to introduce our panelists who very generously are sharing their time with us and their expertise with us today. And then I will take just a few minutes to not even define, but kind of create a foundation around what I'm talking about when I talk about pretrial, and give you maybe just a couple of statistics or a little information that's specific to Delaware County before we start engaging our panelists. They will each have an opportunity to address you all directly for about 5 minutes to give you a sense of who they are and what some of how their expertise pertains to this topic. And then we'll engage in a question and answer session that I will lead a series of question and answers, and then we'll go into a more conversational style portion of the session. So very quickly, and I'm going in alphabetical order here, and I should say my pronouns are she, hers. I tend to address individuals in this setting by their first name, but I don't want to be disrespectful to people with the amount of expertise that they bring. So sometimes you'll hear me slip back and forth with the formalities. But so going in order, I have Anton Andrew is a public affairs fellow for the Pennsylvania Prison Society, working to increase the society's visibility in legislative offices, support education efforts, and explore ways to sustain strategic advocacy campaigns. Anton has spent the past 25 years as a public defender, educator, and local activist fighting to protect people and communities whose voices have been historically ignored. Heather Lewis is whose title here is Reuniting Families, and I forget the last part because it's not showing up on my screen, but her goes by the name of Heather Lewis, is a 20-year nonprofit professional committed to serving the most vulnerable in our communities while being a champion for social and criminal justice reform in Montgomery County, our neighboring county here in Pennsylvania. As an executive director for the Reuniting Family Bail Fund, Heather is able to attack these systems in a way that is not hindered nor influenced by the threat of job security. Also, as a national trainer for the National Participatory Defense Network, Heather is able to empower families to learn the criminal injustice system and fight alongside other families in similar situations seeking justice. We also have with us Hayley Pritchard, who is a legal fellow at the ACLU of Pennsylvania, where her work focuses on combating pretrial and probation-related detention through litigation and other advocacy efforts. Hayley's a recent graduate of UPenn Law School, holds an MSc, which admittedly I don't even recognize what that is, so hopefully she'll educate me on that, in sex, gender, and violence from the University of Aberdeen, and received her undergraduate degree from the University of North Florida. Prior to graduate school, Hayley worked in the research department of a policy center focused on the experiences of girls and young women involved in the juvenile justice system. So very shortly, we're going to jump to each of them so that you'll get to know them a little better. But before we do, some of you may have entered this forum not knowing exactly what we mean even when we talk about pretrial, which it would be totally normal for those who are not operating in the space of our criminal system. So when I talk about pretrial, I'm really talking about a population of people who have not yet had their moment in court to present their evidence and or have an attorney to defend them in relation to charges being lodged against them. Statistically here in Delaware County, when the jail talks about their jailed pretrial population, they're grouping together people who are faced with new charges, meaning, a new crime. They are accused of that crime and have not yet been in front of a judge to address those accusations. It also, here in Delaware County, the pretrial could constitute people on probation who are not necessarily convicted of a new crime at all, but are under community supervision out in the community, and the probation office has determined that they should come back in and by alleged violations of their allegation, similar to those who are in detention on other types of pretrial conditions. Those who are in on probation violations have not yet had their hearing on those allegations. So those people get grouped in, and then there's also a subset of people who may be brought in, arrested because they have not shown up to court dates. So we're talking about a population that is in there, not sentenced, not serving a sentence, but they are awaiting their hearing to address the issues that the accusations lodged against them. We're going to hear a lot about the term bail. So once someone is charged with a crime, before they go before a judge, before they even interact with an attorney, a fairly low-paid government official here in Delaware County is going to make an assessment and recommendation as to whether that person should be at liberty or whether they should be jailed until they get to be in front of the judge and until they get to defend themselves. Most often, the outcome is that the recommendation is adopted by a magisterial district judge in full or in part, and the person is found to be bailable, meaning they get to be, they could be at liberty, but they probably have to meet some conditions. Those conditions can be a variety of things. Most frequently, we see cash bail, meaning if they pay a certain amount of money, they get out. There may also be drug and alcohol evaluations, which is legally questionable, but happens with some frequency here in Delaware County, where they say once they get a drug and alcohol evaluation from the jail, if we find that that renders them safe, then they can go. Or they might need a verifiable address before they can be released. So what does that mean for the population that is in pretrial? Most often comprised of poor people who don't have the money to pay, or those with mental illness or addiction issues who are awaiting that drug evaluation or assessment, and the homelessness, people who don't have an acceptable verified address. And all of our speakers will talk to different parts of that. Real quickly, I want to give you some statistics about Delaware County in particular. So in 2019, there were approximately 9,700 people throughout the course of the year that went to our local jail. And when we're talking pretrial, the vast majority are going to be at our local jail, George W. Hill. That's over the course of the year, but the daily population in that year was about 1,775. So how do you go from 1,775 people in the course of a day to 9,700 in the course of the year? What that means is you're seeing a rotating population. Those are not people who are serving county sentences after being charged with a crime. Those are people who are in, they have some business with the court and they're staying in until decision makers think they can get out. Now, right now, that population is lower because of the pandemic across the state and country. More people were let out pre-trial, but we are at 1,326 was the daily statistic that I got today. The warden in November of last year estimated that about 91% of that daily population is pre-trial. Back in May, when the pandemic started, around the early part of the pandemic, our population was down to 900. So now between May and now, we've, like in the cycle of that year, we've gone back up about 425 people. And our crime rate is not proportionally back up, right? What makes the difference there is the discretion by decision makers to jail people or not. Of the statistics that were presented by our former warden in November of 2020 were that approximately 89% of the people in jail were male, 61% are Black, 36% from Chester, 77% on some kind of medication, 23% stay more than 2 months. So that's more than 60 days. Less than 1/2 get out in under 2 weeks. And approximately 1/3 are in there for 15 to 60 days. So with that background information, I am going to turn it over. And I think I'm going to go ahead in order as well, just for ease of me, and we'll be jumping around to all of those different statistics that I flew your way. I think each of our speakers will address them from different angles. So Anton, Andrew, are you able to take it away? We will need to help you out with some slides.
Yeah, no, Lee, thank you very much. And I want to thank the League of Women Voters and the NAACP chapters who are responsible for putting on the event. My name is Anton Andrew, and Lee gave you my bio. Basically, you know, my entire adult life, I've been fighting to make sure that populations that are invisible or don't have a voice have the opportunity to be heard. And you can tell from those statistics that Lee is giving you that probably there is no population that is more vulnerable and no population that is more invisible, because I think those numbers probably startle a lot of people listening on this call, than people who are incarcerated in Pennsylvania. And that's something that our founding fathers knew would happen, which is ironically why, or coincidentally, why we are the oldest human rights organization in the country. And we is the Pennsylvania Prison Society. Benjamin Franklin and Benjamin Rush, you may know those names, created the Prison Society at the same time they were creating Pennsylvania's carceral system back in 1787, because they knew that in order to have a system of corrections which is truly humane, you need to have independent oversight. And that's exactly what we do. So basically, our area of work focuses in 3 main buckets. One is our prison monitoring, which goal in a nutshell is to stop abuse in prisons and jails. And we do that largely through our volunteers. We have over 300 volunteers across the state who are called official visitors, and they have, for lack of a better word, gold key access. They have the same access an attorney would have to his or her client if they're in custody. So they can go into any facility in the state, any state correction or any county facility, and speak with someone who's in custody there, either at the bequest of that person or bequest of somebody who's part of their family, if there are concerns around that person's treatment or the conditions that they're living in. We also have a social services program where we make sure that we keep people who are in custody and their families and their connections in the outside connected, because unless you are sentenced to life in prison without the possibility of parole, you are going to be coming back out. So we believe that the first day you go in is the first day you begin preparing for returning. And so that's what our social services are focused on. And we do mentoring, we do training programs to prepare people to return to their communities. And finally, we do education and advocacy. Because of the access we have through our volunteers, through our programs, we're able to gather a lot of information. Our surveys during COVID-19 largely informed some of the decision-making process for the Department of Corrections. If any of you guys are junkies for appropriation hearings like I am, you'll notice that Secretary Wetzel, the head of the DOC, during the budget hearings, was consistently referring to a document where he was talking about, well, we've made these changes and they've helped us mitigate against the outbreak of COVID-19. And those changes came from the surveys that we'd done and our findings about what the department was doing and wasn't doing well in terms of little things like people wouldn't think about in terms of communicating to people in custody what exactly was going on and what they were going to do to mitigate for that, including having enough hygienic supplies now that people were spending 23 hours in custody, and including suspending the $5 medical copay, and I'll talk about that a little bit later, which the department charges inmates for sick visits. So those are the kinds of areas that we can inform decision makers as well as the public. And again, I'll talk about more opportunities for people to jump in later in terms of making sure that we truly have a system that serves the people who are incarcerated as well as the people who work in those facilities.
Great, thank you very much. And I know there was a slide presentation. I hope that was not supposed to go up while you were talking.
Thank
you're
you.
muted.
Thank you so much. I'm going to, there's one thing I wanted to share. To give you an idea of the work we do, we get over 300 correspondences a month from people who are in custody or their family members. And because of our network of volunteers, because of our staff, we're able to respond to each and every one. And I just want to give you an idea of the kind of things that are coming into us on a regular basis. So if we'd be kind enough to just play a snippet of 3 calls, which are, sort of the typical kinds of calls that we're getting on a daily basis at the Prison Society. And there's a little pause at the beginning, so I'll talk until she drops.
Hello. I'm calling about my grandson. He's in the prison in Flattsville. He's been in the hole for all summer, and I'm trying to find out why.
I'm calling in regards to my husband. He is, they just moved him to SCI Laurel Highland about 2 weeks. He is calling and he has had a heart attack back in 2015. He's now calling and telling me he's having chest pain and all kinds of other medical things. I called down to the prison and they're telling me, well, he's going to a stressor in 2 weeks. But they got really nasty with me on the phone. I told them I would get in touch with my state representatives because I feel that they're kind of brushing it under the table.
I'm calling for a loved one in prison, Lancaster County Prison. He called me. He's asking for help. He was beat before he got to the prison, and he's in really bad shape, and nobody's helping him. He said the cops beat him really bad for a probation violation, that he had nothing on him. He said the prison's not helping him.
So, again, these are the kinds of things that we problem solve on an individual and systemic level. And these are the things that we're going to, as long as we have a system of mass incarceration, here in Pennsylvania, we quintupled our prison population in the last 40 years. That's frightening. And as long as we have that in place, organizations like ours are going to be responding, to concerns like this, and look forward to being a part of this discussion and part of this group offering possible solutions moving forward.
Thank you so much. Those recordings were very powerful and visceral and hard to hear, but so important. Our office receives calls like that way too frequently. And I'll add that Delaware County's incarceration rates exceed that of the state statistics. So I think as much as it's hard for people to hear the pain of others, that is a very real part of what we were talking about. And it's a good segue to introduce you to Heather Lewis, who works a lot on a variety of issues, including assisting families as they watch their loved ones go through this horrible and traumatic system.
Thank you, Lee. Thank you, Anton. Both your statistics and the explanation of what's going on in Delaware County, and then those phone calls from the Prison Society is exactly the fight that we fight every day, why we support families. The system is designed, just like that quote says, for folks to be forgotten, to be tossed away. We change our language. We don't use, the word inmate. We don't use convict. We don't use ex-con, or, the language is constantly changing to remind ourselves that these are human beings that we're talking about. And I like my job. It's like I said in my bio, I don't have to be politically correct. Most often, Lee was very nice when she was talking about the system and things like, and no, people, when you talk about people being held pre-trial, they are being held in prison and they have not been convicted of a crime. They've been charged, but they have not been convicted. And that is a huge issue here in Montgomery County. And we used to have a very friendly relationship with the government and our public defender's office here up until a little over a year ago, when our chief and deputy public defenders were fired for blowing the whistle, so to speak, on our district judges for applying bail to folks who did not have representation. And, there's different interpretations of the law, but the law says in the likelihood of incarceration, you need to have an attorney. And oftentimes, more often than not, folks are going to jail, assigned bail without an attorney present. And that is a practice that we are aggressively fighting and trying to draw attention to, continuing the work of Dean and Keisha and making sure that that does not continue to happen. We also, so I get passionate about this stuff, so I may jump around a little bit because, we do the bail fund, but my work is rooted in participatory defense. And so what participatory defense is we're working directly with families who have a loved one who's fighting a criminal case, no matter what stage in the process they are. We do from, arrests, so that folks are saying, hey, my loved one didn't come home last night. I can't find him or her, and then we start the process of trying to find them. They think they may have been incarcerated or arrested. There are times where, folks are incarcerated, like Lee had said, and they've been assigned bail and don't know how to get that. And oftentimes it's 30 days, 45 days. They're taking great lengths to utilize COVID as an excuse to hold people even longer and assign even higher bail. So it's not uncommon, it's not surprising that the numbers are going back up for people being held prior to conviction. And so, at any point in time that, someone reaches out to us to help, support their loved one, we do. And with impressive results. It's not, and I'm a non-attorney. I'm probably the only non-attorney on this panel. And what we do is empower families to understand the process, to understand what lawyers understand as far as the process. They don't need to understand the law, so to speak, but they need to understand what's happening next. So that way their anxiety level is taken down. They can focus and process exactly what they want to communicate to their loved one's attorney or what they need to do. We have we know some of the public defenders. So if we have someone that has somebody that we recognize, they say, hey, that's a good place to be. You know what I mean? We can work with them. They'll respond. This is how they respond best. If they're in court, text messaging is good. Like there's all these little nuances that folks can really kind of increase the likelihood of their loved one being heard and seen as a human being. So that's participatory defense. And, so I'll touch on some of the things. What can people do? So pre-COVID, we were going to court with families. We were helping them draft emails and setting up emails if family, if the loved one doesn't have one. Some of them are, grandmothers are taking care of their great grandchildren and finding that their great grandchildren are, become incarcerated. So helping them with the technology and being able to communicate and understand. When we're in court, we're watching the judge, we're watching the DA. If it's a trial, we're watching the jury and witnesses, and we're taking notes. And, so there may be 3 or 4 of us. And not only that we're just taking notes, but the fact that we are in the courtroom. How often do we see, it's not like it's on television, Law and Order, and that courtroom is packed. It's usually the defendant, their attorney, and the prosecutor, the whole team of prosecutors and the judge and some sheriffs and, the bailiff and all these system folks. And rarely is there anyone there for the defendant. And so that system just kind of operates in its own little bubble at their discretion. That's a word they like to use also. So the fact that we are there watching straightens them up a little bit. The judge will straighten his tie and dust off his robe and use the appropriate language. We'll use the appropriate process because now we are there with pen and paper, taking notes, observing. So that's one thing. And even now that we're doing Zoom, that folks can really do is observe hearings. That is our right to observe hearings. And so even if it's Zoom. So that's another issue that we're taking up fight with, is that our district judges are now requiring permission. We have to tell them a week in advance that, they want to have, that the person facing a hearing wants to have family support. Well, if they just were going in person, they wouldn't have to get permission and, get all these clearances. Now with COVID, we have to get clearance. They have to check. They're asking permission. Oh, do you want people to be in here watching? When pre-COVID, that wasn't the issue. So absolutely pressing that every hearing that is supposed to be public be made accessible to the public. And so people don't know what they don't know. That's why you all are here to learn. And it's really hard to hear those phone calls. It's really hard to hear that judges are preferring or think that it's better for a female to detox in a room with 20 other women that are detoxing, being guarded by male guards in that environment. Judges think that's best versus going into treatment. I mean, there's obviously financial and other things like that, but that's the discretion and that's the choice that our district judges are making. That's why, this is being hosted by the League of Women Voters. That's where it starts. Our district justices are the ones that are making these decisions. They're the ones that are setting people on a path of incarceration or on a path of healing. And often, incarceration, provides resources for other folks. There's money. And that's really, in my mind, it boils down to money, because that, 9,700 people at $35,000 per person. I don't know if that's the cost there. That's the cost here in Montgomery County. It's a lot of money. And so we threaten to interrupt that money train. We also threaten to pull back the cover and expose some of the illegal and unconstitutional practices that our district justices are doing. There's 30 here in Montgomery County, so there's a lot to look at. So there's definitely work to be done here in Montgomery County. And
Terrific. Thank you so. Oh, I'm sorry. Go ahead.
I don't know if you're looking at the chat. I'm trying to read the chat and not lose my train of thought, but I think there was a question about the language. So we refer to folks on the inside, or, a loved one, just how, when we talk about people with disabilities, we don't talk about disabled person, we talk about people with disabilities. That people comes first. So it's more words to say, but it's definitely the right words to use when we're talking about people on the inside, because then they've been labeled, and when they come home, they're not the people on the inside. They're our loved ones now that are part of our community, that are looking for jobs and looking for housing and looking to, pick up their life and try to move forward as best they can. So even just being mindful of the words that we use helps them a long way. Lee, you're on mute.
I'm sorry, you're muted.
Thank you. The HVAC system in our building likes to come on with this very loud humming. So I'm trying to navigate that. Thank you for letting me know. That was very helpful introduction, and I'm looking forward to circling back to hear more about some of the work specifically with bail. The reference to Montgomery County is near and dear to my heart, and I know that they've had significant struggles there and are grateful for the support of the community, and that community work is essential because it holds all of the stakeholders accountable. Without the community, people are not held accountable, and that goes for my office as well as all of the other stakeholders. Relevant to that, and just by means of a segue into Hayley Pritchard, is the ACLU has also been incredibly active across the state in working on these issues and in educating people around pretrial issues, the role of judges in making those determinations and others. And they were also very active in looking at what happened in Montgomery County around that particular advocacy and the firing of their chief of appeals and, their chief public defender and deputy public defender. So they've been in this fight on the ground and at policy levels. And here today, they're sharing with us the insights and expertise of Hayley Pritchard.
Hi, I just want to say thank you all so much for having me. Thank you, Lee, for the introduction. Thank you, Anton and Heather, for sharing your expertise as well. I'm really glad to be here and able to speak to you all and able to learn from you all as well. As Lee said, I'm Hayley Pritchard. My pronouns are she, hers, and I am a legal fellow at the ACLU of Pennsylvania. The ACLU, of course, focuses on a variety of civil rights and civil liberties issues, but one of our main focuses is the criminal legal system right now. And so the ACLU has a campaign called the Campaign for Smart Justice that is focused on a goal of cutting our prison and jail populations in half as quickly as possible, and also reducing the racial disparities in our system, because as we pointed out with those statistics about Delaware County specifically, those disparities are egregious and pervasive throughout the entire system at every point. So our work takes a couple of different approaches. We bring litigation, usually impact litigation, and what that means is not generally individual cases, but cases on behalf of big groups of people who are experiencing the same problem and trying to solve those systemic issues with one or at least fewer lawsuits. We also work on legislative advocacy at the state level, opposing legislation that would further contribute to the mass incarceration in our state, supporting legislation that would hopefully bring at least some level of reform. And as we said, we also work, in conjunction with other groups on trying to educate the public about the role that different actors play in the system. So you all have heard about magistrate district judges a few times now already, and they are these really low-level judges who have a huge responsibility and a huge role in determining whether people are free pre-trial before they've been convicted, or whether they are sitting in jail waiting for their trial or waiting to be assigned counsel, things like that. So I am, again, looking forward to speaking to you all, and hope I can provide some helpful information.
Thank you, Hayley. And I am keeping an eye on the comments, and that is great. So as they're coming in, I'm writing them down so that I can revisit them in case the speakers aren't able to address them at that moment. The question before us is the league is having a candidates forum for common pleas judge candidates tonight. What should we ask them about their views on bail, since it is at the judge's discretion? So I'll have the speakers have that in their head. We have some other questions we're going to get to first, and then we'll circle back. I meant to have it out for you, and I haven't gotten it circulated just yet, but I will be circulating it after this. There was I think it was just yesterday, a great publication called The Appeal has released a very good summary of how judges, specifically in Pennsylvania, affect these decisions. So it really lays it out in for people who may be hearing all these different words but haven't really gotten the big picture, basic foundation. And I'll circulate that out to everyone. It might be for people who have questions like that for the candidates. It would be probably interesting reading. So I'm going to, all of our speakers have kind of touched on this with their introductions, but I'd like to go a little deeper. So really looking at our current pretrial detention systems, what specific problems do you see, keeping in mind the question of what can individuals here in Delaware County do to work towards fixing them? So that's a big question. I'm going to break it down into different categories. And the first is going to be directed to Heather around bail. And I'm hoping that she can talk to us a little bit about the work she has tried to do in Delaware County to establish a bail fund, and what her thoughts are on the cash bail system and kind of what problems she's seeing. It's a big question. So there you go.
Thank you, Lee. It's interesting. Like I said, the dynamic shifted, the energy, the environment completely shifted. And, you know, in a sense, I'm glad it did, because we're able to really dig in to the work and really get at the root of what's happening. And it's kind of manifesting itself with the through the public defender's office and the commissioners and things like that. When we were building the bail fund, we had already been doing participatory defense for 5 years, partnering and working closely with the public defender's office, with Dean in particular. It was his idea to start the bail fund. We talked about it, but hindsight is saying it to me now, and we've talked about the pretrial program. That's a whole nother animal that we can kind of touch on. But this pretrial program that is coming out of the court system is its own checks and balances, so to speak. And just like Anton is here to be the check and balance for the prison, the jail system, how is it that the court is now creating its own checks for itself? So in a sense, that's what the pretrial program is set up supposed to do. There's risk assessment tools of determining, you know, in advance whether or not they think someone will reoffend or not appear or be a danger to the community, when essentially that's already what the judge is supposed to determine. So that's why the judge is there, is determine that. So now they're taking a whole nother look at it and diverting resources. So this isn't free. They're diverting resources to this particular program. So when I mentioned before about diversion courts and other alternatives to incarceration, there's mental health, there's drug and alcohol, homelessness. There's a whole slew of things that can be addressed without incarceration. So with that being said, we were still amongst friends in November of 2019. February 2020, all that changed. the work. I was talking to the warden, I was talking with the caseworkers up at the prison, trying to say, hey, this is what we're doing. They're like, oh, this is great. Then all of a sudden, after Dean and Keisha left, the communication stopped. So there hasn't been that relationship. And I'll talk about Philadelphia. Philadelphia, they have 2 bail funds, and they have a great relationship with the court. The public defender's office refers people. That's how they're able to do like the Mother's Day bailout, Father's Day, all these holiday bailouts, because they're getting referrals from the public defender's office.
And
They have
Heather,
that
I apologize. I'm just going to interrupt you for a minute because
Sure.
I'm not sure that some folks on this meeting may not know what a bail fund is.
Okay, so bail fund is a free service. We're not a bail bondsman. We are a nonprofit organization that receives donations that we can post the bail for folks for free. Now, our cap is $5,000. We're, so there's philosophy behind, abolitionists and things like that. Bail fund work is talking about, it's not about the charges, about the system, and really just having people fight their cases from home versus being held pretrial. And then, some in Philadelphia, some folks their cases are dismissed. So if they're held pretrial, then they've served time for nothing. And so a bail fund is a free service where a bail bonds charges a fee to the family to get their loved one released. So we are a free service. So we're a free service to the community. We work by referral only. So the fact that folks need to know that we exist is key. And because we want to be responsible. There are folks that don't want to be bailed out. There are folks that, are incompetent and can't make that decision. So there are some, areas that, we understand. But, a large percentage of the folks that we are seeing that are being held pretrial here in Montgomery County is for retail theft. And the going rate is $5,000. So majority of the retail theft that you see, somebody's going to be held pre-trial for $5,000. They'll go to court and have their first hearing, supposed to be, 14 to 21 days. We're seeing anywhere from 30 to 45 days before they get before a judge to see if they can have their bail reduced. Often their bail is reduced, and then they'll have to come back in a couple of months to face the balance of their charges. But in that 35 to 40 days, people have lost their housing, they've lost their job, they've lost their children. They're having to do all of these things to try and keep their life together so that they can get out. That's the purpose of the bail fund, so that we can post that $5,000 bail. They can get back home and get back to work. They can take care of their kids. They can, at least try to hold whatever it is that they, their life together, so that they can get the resources. If it's a drug and alcohol problem, we have the referrals and things like that. Leah, I hope I'm answering your question, because I can talk all around this all day long. So.
Yeah, no, I think that was incredibly helpful to let people have that picture, kind of what we're talking about when we're talking about bail and what the bail fund is, and some of the challenges that I heard you raise, in addition to just the system itself, is accountability is one that's a big problem, right? Because you described a pretrial system in which the people who are being evaluated are the same people who are supposed to be holding themselves accountable, and we all should be holding ourselves accountable, but that's not necessarily the way we want it to work in government. And then you raised risk assessment tools, and I see there's a question about, how accurate is your view of assessment tools? And
they're very accurate at sending people to jail. I'll say that.
So the question, and when you were discussing risk assessment tools, I think you also talked about kind of a double application in the context of pretrial. You mentioned diverting resources. So the amount of resources that we are putting toward figuring out.
Yeah, it's hundreds of thousands of dollars. This pretrial program is going to cost Montgomery County residents.
Yep. And then I think you also got it challenging relationships between communities, advocates, different agencies, in terms of, when the relationships are good, it sounds like you were able to have more of an active role in assisting individuals and their families. And then when those relationships shifted, it made things much harder. So
Yeah, I think they're doing a really good job of looking like they want to control the change instead of allowing the change that needs to happen. They want to control the change. And that's not effective.
So thank you. And apologize, I went on mute for a second there. So you have a lot of focus on the economic impact of stays, and you mentioned kind of some of the ways these fees can come up, even if you're not, we're not talking cost and fines, but just being in a jail facility before you're even, going to court to defend yourself, things can come up.
Yeah.
Can you talk to us a little more about the economic impact of a short stay?
Sure. First of all, I'll point out, as a former public defender, a short stay is a double-edged sword. If you're in for a very short period of time, it's most likely because you've pled out, and then you're going to have significant costs and fees assessed as part of your plea. Either you're in a pretrial program where there are fees associated with that program, or you got bail, or you made bail, I should say. And again, aside from the bail fund, that's a significant outlay of money. And when you look at the fact that between 2/3 and 3/4 of the people, depending on the counties in the state of Pennsylvania, qualify as indigent and qualify for a public defender for that reason, you get out on a short stay, you're on borrowed money. And what I mean by that is, typically it is the family members of the people who are incarcerated who are paying those fees to get them out on those short stays. And a recent study we did, 1 in 3 families for inmates, even for people who are incarcerated, even for a short stay, go into debt simply to either return those members to their communities or just staying in contact, whether it's through phone calls or video chats. And I'm not going to spend time going into that now unless we have time later, but there are all sorts of hidden fees there. So whether you're paying to get out by pretrial, by plea, by bail, or you stay in for a slightly longer time because you're contesting, or you simply don't have the funds to get out, which then creates a tremendous impact because you've now probably lost work, you've lost housing, or you're at least at risk of losing housing, and your family that relies upon you, or you are a contributing member of, no longer has that income, and instead is spending what is a considerable amount just to keep in connectivity with you and just to allow you to navigate the system safely. There is no shortcut. So saying a short stay is really it is not a really accurate portrayal of what happened. You have to buy your way basically out of custody, and the very people who are getting locked up most are legally determined to be the ones who are least likely to be able to buy their way out of custody. So either that's somebody else going into debt for you, or you're staying in custody and further reducing your chances of coming out of that without accruing significant debt. So so in essence, basically, there is no way not to get harmed once you're sucked into the system.
So, and pulling on your public defender background, you mentioned this a little bit, but can you talk a little bit about the effect of that pretrial detention on one's defense? And, you mentioned pleas, and kind of that tension around liberty, defending, and pleas.
Yeah, I would tell my clients, because it creates a tension with your clients, because nobody wants to stay in custody. And as their attorney, you're obliged to let them know, well, here are your options for getting out of custody. Either you take a plea, which for somebody you've met for 30 seconds is the last thing you want to hear, especially since you're supposed to be their advocate in court, or you pay significant fees to get yourself out, whether you bail or you lucky enough to find a pretrial program that you fit in. And again, those are significant sacrifices for somebody who's already been determined by the court to not be able to pay for those services, essentially. So you're saying you now have to rely on your family members. So that strains the relationship between the client and the attorney. And it also reinforces the perception with, somebody who's in custody that the system really is milking them for everything they can get. And that is the primary purpose of the system, because the first thing your lawyer is telling you is, here are your options to pay to get out of jail, basically. That not only creates a financial burden for people, but it also really chills their opportunity to have a zealous and advocate fighting of whatever accusations are against them. And which is why every single case I ever pled, I've said, Judge, I just want it on the record, this is a plea of convenience. And because in many cases, that is the only way my clients are able, that is the least harmful aspect of, or the least harmful option for them, because contesting is too time consuming and too expensive.
Thanks. And there's a question in the chat about the caseload for public defenders, and that's something I can kind of circle back to here in Delaware County. So that's my bailiwick. I can circle back to it a little, but it ties into a lot of your comments, because one of the other ways we see people accruing debt, unfortunately, is even though people who cannot afford an attorney constitutionally have a right, like it's built into our system that everyone has an attorney. If the state is going to reach in and make decisions over their bodies and their lives, you have the right to counsel. And that's what public defenders do. But public defenders, for a variety of reasons, are not trusted, perceived as providing a solid defense. In some instances are not providing a solid defense. And so a lot of families just feel better and safer by having private counsel. And all of us often fall to the mythical story of the United States that when you pay for things, whether it's corporations or other things, that you're somehow going to get better services. But in some cases that can certainly be true, and it plays out. So families will go into debt, like people will mortgage houses in order to get counsel for their loved ones as well. I really want to address a question about caseloads, but I also want to keep on topic and get to questions for Ms. Pritchard about probation problems. But I will circle back. I will tell you that and very quickly, there are national standards for caseloads that are calculated in a lot of different ways. And there is not much data or information about what the caseloads are here in Delaware County, and that's something our office is working on. I do not believe at this time that our caseloads exceed those national standards, but I do believe at this time that our office has a lot of work to do in terms of our historical representation and bringing that and improving the services that our clients deserve and need. So if there's more time, I can talk more to that, but I'd like to turn real quickly to Ms. Pritchard. The question kind of we're getting at, what are some of the problems with our current system of pretrial detention? And one population that has not been touched on much, but is in your bailiwick of expertise, is pretrial detention for those who are in on probation violations. I'm wondering if you have any thoughts to share with us on that.
Yes, and just quickly before I get into probation, I just wanted to touch on a few of the things that Anton and Heather mentioned. One being this issue that pretrial detention, whether because of unaffordable bail or because of probation, is really a mechanism that allows just mass coercion of guilty pleas. I think that's a dynamic that's really important to be aware of, and that's something that people impacted by the system have known, and that's something that public defenders have known. Just because I've worked with it recently, I also want to let you all know that there is now also an emerging body of social science research that uses new methods to really show that pretrial incarceration causes worse case outcomes, in a way where people used to just say, oh, it looks like they correlate. You're detained pretrial and also these outcomes are bad. They can now show that one is causing the other. And so we are causing people increased likelihood of conviction, largely through guilty pleas. We are in some cases causing longer sentences by incarcerating people pre-trial. So just wanted to highlight that part again. In terms of the probation system, as we mentioned, this is also a real driver of incarceration across the country, in Pennsylvania, and it sounds like in Delco specifically. Pennsylvania is actually, the last I looked, second in the nation behind Georgia for how many people we have under state supervision, which would be probation or parole. And some of the issues that I see and that you all could be aware of as you look for places to plug into work are, first of all, that terms of probation can be really long. And this might depend on local rules to some extent, but in Pennsylvania generally, you can be on probation for really as long as you would have been incarcerated, which can be a long time. And when you're on probation, you have all of these conditions put on you that really subject you to surveillance and consequences that another person not on probation would not be subject to. So these conditions can include things like getting permission to change where you live, letting a probation officer search your house or your car at any time. There can be employment requirements, community service requirements, there can be curfews, there can be costs associated with it. There can be rules about not consuming alcohol or having to attend counseling, not possessing firearms. So the list of conditions that can be put on you is huge, and it sort of functions as this kind of trap where you're expected to live for really long periods of time without ever messing up. And if you do mess up, you can be sent back into the system. And so you can be sent back into the system in two ways. What we call a direct violation is generally being charged with a new offense, and then being accused of a technical violation is when you are accused of violating one of those conditions of probation that would not be illegal for someone else. So it's not a crime, and it wouldn't end up in incarceration for anyone except that you were already on probation. And this was a rule that the court could put on you in particular. And so you end up routed back in. When the system has already clearly decided that you're not actually a threat to public safety in any way. So those are the two kind of big picture things I would think about: really long sentences with a lot of conditions and expecting people to navigate that while functioning under a lot of surveillance by the state. The other thing is that your due process rights are much more limited as somebody who is on probation. If you're accused of violating a condition of probation, it results in something called a detainer being issued, a probation detainer, which means that you can be reincarcerated. And there are some procedural requirements that should happen after that. You're entitled to 2 different hearings. And I hope this is clear. I'm happy to answer follow-up questions, but you should get what we call a Gagnon 1 hearing, and it's called that because of the Supreme Court case that decided it. So we call it a Gagnon 1 hearing, and it's to see if there's probable cause that you violated the condition of your probation at all. And that's supposed to happen really quickly. Supposed to, does not always. And then later you have a Gagnon 2 hearing, which is about a more thorough hearing to see if you actually did violate a condition of your probation or parole. And again, the first hearing is supposed to be really pretty immediately, and the second hearing is supposed to be within a reasonable amount of time. In reality, we know that across Pennsylvania, people are sitting on these probation detainers incarcerated for months at a time, waiting to even get to the point where they have real hearing to see if they actually violated the condition of their probation or parole. And so you have the same issue where people might say, actually, yes, I did do that, because that's how they get out of jail again. So I hope that's clear. In terms of good steps, it would be caps on how long you can be on probation, and it would be reducing the conditions put on you as much as possible. And it would be wanting people to have those hearings as quickly as possible once they are accused of violating probation.
So I think that is helpful for a lot of people. There are some circumstances in which the state does have the right to keep someone in after a finding. And I think you mentioned, like, is there probable cause or sufficient evidence to allow someone to stay in jail until that hearing on the actual allegations. There was a question that came my way earlier, and I think some people on this call were interested in better understanding a little bit more around the constitutional, like, what is it constitutionally okay for the state to say someone actually the state can put someone in jail even though they haven't been tried. And that's a big legal question. I don't know that we want to spend too much time on it, but if you feel like tackling that for a few minutes, I think it would be appreciated. And then there's another question directed towards you, which is, can you comment on how those conditions of probation limit possibilities for reestablishing a normal and productive life? Like, how do those conditions limit housing, employment, socializing, et cetera? And
Sure. So I don't want to end up taking a whole lot of time and space trying to answer the legal questions. I would say the exact parameters around incarceration after being accused of probation prior to that ultimate hearing are a little unclear. It seems true that people should not be sitting in jail for months. But the standards aren't exactly clear right now. It also seems true that somebody who is accused of just a technical violation where they've just violated one of these, like a curfew or missed an appointment, that shouldn't mean you can be sitting in jail if you're not any kind of threat to other people. But again, I'm not sure that is clear right now. I will say, going back to the bail discussion that we've been having, there are a lot of constitutional principles that are relevant to when you can be incarcerated on bail. We're supposed to have a presumption of innocence. There's supposed to be a presumption of pretrial liberty. Bail is not supposed to be excessive if the purpose is to make you appear in court. It shouldn't be set in an amount that is wildly beyond serving that purpose. Also, for purposes of framing, I think it's important to understand that bail is supposed to be a mechanism of release. The purpose of bail is to get people back into their communities with a little bit of assurance that they have a stake in showing up at their next court date. The way it is used in practice is to keep people detained, which is the exact opposite of what it should be. The Pennsylvania Constitution actually says with certain limited exceptions, that all prisoners shall be bailable. Everyone should be released unless there is a real concern about public safety or flight risk. And we have a lot of good rules of criminal procedure in Pennsylvania that judges are supposed to follow, kind of operationalizing these principles. These magistrate district judges should be asking first whether you can just be released without any conditions of bail, assuming you'll show up. It should be like the least restrictive option first. If they decide that cash bail needs to be set, they absolutely, based on our law, have to ask about financial circumstances and ability to pay. That doesn't happen in real life. So one of our kind of common forms of advocacy in different ways is just asking that these magistrate district judges across the state actually follow the law in Pennsylvania as it exists. So we think that based on the Pennsylvania Constitution and our rules, pretrial detention on unaffordable bail should be very, very rare in Pennsylvania. It is not rare by any stretch of the imagination. But that means that we generally are not advocating for legislative reform on the topic of the bail system. We are asking that people start by following the rules already in place. In terms of, and Lee, feel free to jump in if you want to redirect me at any point, but.
That's fine. I actually,
oh, yeah.
that's a great place to jump in because you mentioned the magisterial district judges. We often refer to them as MDJs. It's a helpful reminder that most of those are elected positions and people don't have to be attorneys, right? They get a judge training, but they're not always attorneys. In fact, the majority I don't think are. And so anytime anyone comes into a new position, they can be the best hearted person with a strong mind. But if the system around you is in habits of doing certain things, it takes a lot of disruption of habit to rewire for our own brains and our own systems. And so what Hayley is talking about, that we actually have these rules of procedure that are pretty clear, is a phenomenon that drives me crazy on a daily basis, that I try to just talk to all of the people operating this system, be like, can someone please just look at these rules? Because this is what it is. Like, bail means conditions to get someone to appear. It doesn't mean keeping someone in jail. Sorry, I'm the moderator, not the speaker. What I'm going to do though, is I am going to post in this message chat a link to the appeal article that I referenced earlier that talks about the roles of judges in these decisions. And I think this is a great time to circle to our other panelists with big questions, but questions that have been presented on many people's minds, which are and actually appear in the chat. What are some initiatives that are present in Harrisburg right now about which we might be aware that could touch on these issues? If anyone has any thoughts on that, we'd love to hear them.
Sure, I'll jump in. So there were initiatives following up on what was just said in terms of probation and parole reform that were bipartisan in Harrisburg and were very promising, including limiting the length of probation sentences, in the jargon, putting a cap so that your length of probation could not exceed the time you could have served should you initially have been convicted. A lot of people may remember the Meek Mill case, and that was an example of where he was on probation for a long period of time and then had a minor violation and then was sentenced for an additional period of years, which would have put him well beyond how much he could have initially been sentenced in originally. Those pieces of legislations unfortunately went through committees which cut out really a lot of the most important parts of those bipartisan efforts, which was to have the hard caps and to allow people to terminate probation without accruing a ton of additional fines and a ton of additional costs. So with regard to probation and parole, it's back to the drawing board. There are a lot of criminal justice reform efforts going on, not so much about costs, in terms of there's the medical parole. I believe Senator Baker, that was proposed. There's also proposals to shift people who are in custody and who are ill, to move them into nursing homes as opposed to keeping them in custody, which is not only more humane, but actually saves the state money. And there are a whole slate of legislation that has at least initial bipartisan support. A lot of those have been in the back burner because of COVID-19. But, our organization, we have we have weekly updates about what's going on with regard to people who are in custody, and including talking about legislation. And happy to share that. If somebody wants to reach out to me, happy to share the latest copy that of the information so people can keep abreast, because these things come and they go. But for what it's worth, criminal justice reform, because criminal justice system is so incredibly expensive. If you look at the state correctional institutions, the 24 that we have, we spend $2.7 billion just the Department of Corrections, just on the state level, even as the population has shrunk over the last few years and the budget keeps shooting up. And it is because we have to pay so much more for an aging, a sicker population, and a lot of time because of court cases, the ACLU helping on many of those, in terms of forcing the Department of Corrections to give inmates the care that they need. So basically what I'm saying is, it is so expensive right now, our carceral system, even as, at least on the state level, we are shrinking our population a little, or plateaued, that Republican and Democratic lawmakers, not purely out of a care for their fellow human, but also out of a sense of fiscal responsibility, are saying we need to decrease these populations. But again, that doesn't happen without them being reminded of that by voters. And that means when organizations like ours make calls to action, having groups like this and individual supporters call their state senators, call their state representatives to let them know. And so, I won't jump into the individuals, because we could be here all morning talking about the individual bills and where they are in process, but happy to, provide that information offline, or should you want to share your email information with Lee, I can, send you the latest copy of our supporter updates.
That'd be terrific. Thank you. And I switched to the Harrisburg legislative question before seeing that Heather had a hand up, and we had just touched on bail, when I know she's doing so much in Montgomery County on the ground and probably has more to say about it. So I wanted to leap back and hear more from her.
Sorry, Heather, I didn't see your hand.
No,
no worries. It's fine, because it's actually worked. I mean, I just wanted to give two real examples to the question in the chat about the impact of incarceration, and probation detainer was one, and then coming home. So I have two real live situations here, so to help maybe put it into context. And then it goes to what Anton was saying, and about the legislation is accountability. So it starts with us. If we're not watching, if we don't know what to look for, just like they said, they carved up this bill and took out all the critical components out. Same thing that they're doing with decriminalizing marijuana. They're carving that thing up and they're taking out the most critical pieces of that. But the probation detainer scenario that we encountered was a young lady who was riding in a car. She was not the driver. The car got pulled over, whatever was going on. I don't know what the situation with the driver, but they took the young lady into custody because she was on probation. She did not commit a crime. She was just merely a passenger in the vehicle. She had sat 4 months before her mother contacted us. She had not had the gag 911. She didn't have an attorney assigned. There was literally nothing happening other than her sitting in the county jail. The minute we got involved and started asking, saying, hey, what's going on? Can somebody look out, check in, see what's going on? Within a month, she was home, no additional charges, but literally she spent 5 months on a detainer that she had not committed a crime. And thankfully her mom, somebody was looking for her. She was somebody's person, and that they reached out to us. And the minute we started asking questions, we got her home. The second scenario, young man, again, and the whole plea deal is like, I'm going to pull my hair out. I'm like, that stuff drives me crazy. Our DA boasts a 98% conviction rate, and it's plea deals. It's not, they're not going to trial. They're not, pleading, fighting these cases. They're holding people pre-trial and twisting their arm and forcing them to take plea deals. It's harmful, all pretrial detention. Hayley, we could have told you that study long before you guys had to get that information. But we have a young man, again, took a plea deal, served 8 of 10 years. He's coming home on parole. They initially approved his mother's residence. For some reason, they went back and said, no, he can't go there. And the second approval was his grandparents' residence. Came back, both were in Montgomery County, different townships. Again, came back that he can't stay here. They got a secondary person. The victim no longer lives in the state. The mom, who is his mother, is disabled, needs him to stay with her, to be her caretaker, all these financial things. He's gotten a job, but these restrictions that Hayley talked about. So now he can't come home to Montgomery County. He can't work in Montgomery County. He can't drive through Montgomery County, or he is threatened, and his parole officer is constantly threatening him with incarceration if any of these things happen. If he loses his job, which he drives, if he gets caught in Montgomery County, that's going to be a violation, and he will be going back to jail. So mom called us. So this is post-conviction now, the work that we're trying to help them figure out what's going on, that they're putting these restrictions, gross restrictions, to the point that he will be homeless. Mom will be destitute because she's running out of funds to pay for things that her son could be helping her with. And so now we're making phone calls and pushing back and writing letters and seeing what is going on here. Somebody needs to take a look at this, because this is it's ridiculous. It's crazy that these conditions are such that he and mom will be in dire straits if nothing is done. So again, accountability. Anton, we need to talk. Hayley, we can talk. It's just building these alliances and these partnerships, and everybody just watching. Even if you just know a little bit, hold on to that little bit and make sure that little bit is getting done right. You know what I mean? People's lives are at stake. When I started doing this work, the statistics really show, that people of color are, 10 times more likely and are certainly the major population. But this is happening to all people. These injustices are happening to everyone if you find yourself in this system. And this is a system you don't want to find yourself in.
Thank you for that. There's one final question that I have from me, and then there's some questions that are about conditions in general, and some very much go to the work of the League of Women Voters that I'll read out. And I'm going to combine those. We have about 10 minutes left in the presentation, so that each of our panelists can address the ones that they feel most comfortable with. So I'll read those out. The big question from all of us and from me is we addressed Harrisburg, and there was someone who posted about what they can do in Chester County. And so I think this group would love to take away next steps for Delaware County. If anyone has thoughts of what could we do here in Delaware County, what's the one or several next steps, what would you recommend if you have thoughts on that? And someone is interested in knowing about the opinion of John Fetterman's role in clemency for the incarcerated. We know that he is up facing an election, and I think people would be curious if anyone on the panel has expertise or opinions around his role on clemency. There's some questions about conditions of incarceration, specifically what type of higher education is available in prison in Pennsylvania, and is mental health counseling available to prisoners, especially pretrial prisoners that have not had trial. And then I think we touched a little on the constitutionality of imprisoning someone. Those are a lot of questions. I don't know that our panelists can address all of them, but I would like to turn it over to them and see which ones they'd be willing to take on. Maybe I'll start alphabetically. I'm going to go in alphabetical order and turn to Anton.
Okay. Yeah, sure. Thank you. Before I address the questions, just want to make sure, because I know we talked about, the focus of this being about the cost of pretrial detention, and want people to take away from this, sort of the big picture. And what we've heard so far, whether it is the costs that are basically extorted from somebody in order to get out of custody, again, going back to either paying bail, pleading guilty, taking a program to get out as soon as you can, or it's the cost that you incur while you're in custody. Costs that people don't often think about. Your commissary, where the typical food items and food and hygiene items are at a 75% markup over what they would be on the outside. And that's a conservative number. Or whether it's phone calls, which the last year for available data shows that the Department of Correction got $4 million in commission fees from the company charging people who are in custody for phone calls. They're paying those commission fees because they're making a 90% profit on those phone calls. And they're paying that back, between 56 and 90% of that profit back to the Department of Corrections in order to maintain those contracts. Or whether it's a tablet, which is now replacing phones, where people have to spend $150 for a tablet. And again, this is somebody making 42 cents an hour at the top end of the scale when you're incarcerated, paying for this tablet. And then this tablet is based upon an incentivized model where you then have to pay more if you want to buy music or entertainment on these tablets. And these tablets are not focused on educating and preparing people for reentry, but rather just getting more of their money, or more accurately, more of their family's money while they're in custody. Or whether it's something as simple as receiving basic health care. We have a $5 medical copay in the state of Pennsylvania for people who have sick visits. Thankfully, the Department of Corrections suspended it during COVID-19 because they realized that puts not only the people who are in custody at risk, but their staff at risk. If people are not getting an opportunity or choosing not to see a medical professional, because a $5 copay for them translates to a $500 copay for a state representative based upon the fact that they're getting 42 cents an hour. So I think the big picture that we need to take away from it is when people are in custody, unless we have people who are on the outside who are advocating for them, we will continue to have a system where the system is built on the back of extorting money from the population that they are locking up and keeping from returning to society. So I won't jump into any of those. I just wanted to sort of give a frame of reference for all the people here. And I'll let my other colleagues in the panel feel free to respond to the specific questions.
So Anton, real quickly on that though, all of those things you mentioned in the context of the Department of Corrections, Delaware County is in the process of evaluating its contract around the management of our local jail. So would an action point, would all of those questions be something that people might want to direct to the oversight board that is engaged in that decision making? Is that a next step or?
Oh, I think we should definitely, yeah. The oversight board, and I believe that they're still looking for people to fill, civilians to offer their insights on that oversight board. Our experience with the prison society is you absolutely need robust oversight. And so that is one way for people to get involved in terms of following the work of the oversight board. There are organizations like Delco CPR that have been involved with bringing, again, raising the voice on the outside for the people who are on the inside. That's another way that we can get people involved. But at this moment, probably the thing that we can do most effectively is, if people are interested, reach out to the panelists and their organizations and get the information you need so that you can make an effective use of your time, in terms of whether it's a letter, a call to action, engaging your friends around these issues. Because sort of working in separate silos, we're not going to build a critical mass necessary to consistently keep these issues at the forefront of our elected policymakers' minds. Because as soon as this meeting is over, if we all go back to our different lives, those people in custody are as invisible as they were when we started this conversation.
Terrific. Thank you so much for your insights. Heather, I'm going to turn it to you and see if you have any thoughts to share on any of those questions, and particularly, the one regarding next steps.
Next steps, I know, Lee, we've probably been emailing back and forth, trying to catch up with each other for quite some time. I'm definitely trying to organize a participatory defense hub in Delco. We right now service the surrounding counties of Philadelphia. There are multiple hubs in Philadelphia, but we service the surrounding counties, and we'll support Philadelphia as well. So but it's definitely more beneficial to have folks that are in that community, that know that system, volunteers, people that are directly impacted. What I mean by that is that either they themselves or had a loved one dealing with the criminal justice system, to work on that. We can certainly support and get a hub set up there. A little bit about, I think, the questions. I like telling stories of what we know. I like telling our stories. And so I kind of touched on it a little bit earlier about the judge's discretion, thinking that it's better for folks with mental health or drug and alcohol dependency to kind of work it out in prison. And to the question, no, they don't get those resources. Like Anton said, it costs $5 to even see the doctor, depending on how long it takes you to see the doctor. So, usually if someone has a mental health disorder, they've already decompensated. They probably haven't been taking their meds. So they're manic, and they're having just all of these issues that the prison medic is not prepared to handle. And again, with, females are all just, so there's a holding cell. Like when you come in, especially with COVID. So if I got arrested today and I'm charged in bail and I can't afford it, I'm going to MCCF. I'm going to go into that same holding cell with 20 other women. Some are positive for COVID. Some may not be positive for COVID. Doesn't matter if I'm positive or negative with COVID. If I have a dependency and I begin to detox from, and this is stories that we've been told because I've never been there. There is not a bathroom inside of that holding cell. So they have to get buzzed to go to the bathroom. Now, I know I've been sick and couldn't wait 5 seconds to get to the bathroom, but to have to wait for a CO to come and escort this woman to the bathroom, accidents are happening. And so you have that times 20. And then you have some females who are a threat to themselves that are being held naked, strapped to beds, being guarded by male officers. So that is the conditions that our women are facing in Montgomery County Correctional Facility. And that comes directly from women that have been held in Montgomery County Correctional Facility. And I say all that to say that, with urgency, that we need to be paying attention. We need to be listening. And I'll jump back right quick with Philadelphia and their bail fund. 70% of the people that they bail out, and they bail out thousands, 70% of those people have their cases dismissed. And so, 40 days, 2 months, 3 months that people are sitting incarcerated, either they are forced to take a plea deal or they get let go, but they've lost 3 months of their life. And so it warrants our attention. You know, and everything, you know, like I said, they're dismissed. So either they, for whatever reason, the charges didn't elevate to, you know, incarceration, or they weren't the person, or, I mean, I'm a part of a national network where folks are facing life in prison and they were on the other side of the state, and the police have picked them up and are holding them pre-trial when they've got receipts and they've got evidence that says, I was not here. I was here having dinner with my family. And so we make the assumption that, you know, because someone got arrested, that they did something. That's not always necessarily the case. Or it's a something that doesn't necessarily warrant incarceration, like retail theft. Or I have an argument with my boyfriend and, you know, somebody calls the police on me, and, you know, one of us goes to jail because that's how the officers feel that day. You know, so there's a lot of scenarios that land people before a judge. Not all of them require incarceration.
Terrific. Thank you so much. That's, you know, these firsthand stories, we can talk all day about a lot of different things that are very, very, very important. But when we really apply it to specific human stories, that's when it stays in our brains and hearts and is both hard and motivating. So we are at a little over, but I understand I have permission to run a few minutes over to get Hayley's last thoughts, and then I will continue to, you know, echo what has already been said here, that our panelists have a wide breadth of experience and expertise, and everyone is welcome to reach out to me or to any of them directly, and I'm sure we would be happy to continue to engage with efforts here in Delaware County. So with that, I'm going to turn it over to Hayley very quickly. Thank you.
Yes, thank you. I'll try to be very quick. I would echo what others have said about looking at, you know, what our organizations, but also even more local organizations are asking, paying attention to the stories of people who are directly impacted, answering calls to action from organizations that are led by people who are directly impacted or work closely with people who are directly impacted. I would say I also know there was a question about mental health services pre-trial, and in general, there's a lot to say about how horrific jails and prisons are for everyone, and in particular, how horrific they are for people with disabilities, whether physical disabilities or mental health conditions. And I think you all could probably have an entire webinar with people who have more of that specific expertise. But when we're talking about being separated from your community, separated from your family, separated from any services or therapy that you had access to before, disruptions in your medication, being confined in traumatic circumstances, there's a lot to say there. And I'm probably not the expert to give you all the information you would want, but just flagging that as something you all might want to delve further into if you're interested in this area. Other than that, I would flag for you all that the ACLU of Pennsylvania is working on a few resources that aren't out yet, but that might be interesting to you all when they do come out. One of them is a report called More Law, Less Justice, and an earlier version of that report already exists and is on our website, basically about how our legislature in Pennsylvania continues every year to add more criminal offenses, more criminal penalties, more punitive sentences, and what that means for the number of people getting caught up in the system and getting stuck in the system. The other thing that we're working on is a statewide bail report that could provide more information about how bail functions across the state and how magistrate district judges in different counties are impacting people's, you know, freedom and lives in really significant ways. So I would encourage you all to look out for those, and just thank you again so much for your interest and for having us all and for putting this event on.
Well, thank you to all of our panelists. I very much appreciate it. And to all of you at the League of Women Voters for sure, but also the specific individuals who make the League. It's midday, it's a beautiful day. There are lots of things that you all could be doing in your individual lives. And you've chosen to be with us to talk about criminal justice, and that means a lot. And one of the messages that has come through time and time again is that without community, staying with individuals who are otherwise getting disappeared in our systems, the wrongs and things that we can correct will go uncorrected. So thank you for your time, and thank you for hosting this. I will note that all of our panelists have posted some contact information in case you want to send emails, and I remain available to the league and to others to address questions and put people in contact with different resources. We look forward to panel number 2 on this issue. And with that, I'll put myself on mute and end with a thank you.
Okay. And now the league and the NAACP would like to thank you for a wow presentation. You know, Lee and Heather, Hayley and Anton, it was excellent. Your multifaceted approach is truly a model for the league. And so when a person goes to jail, I heard the entire family goes to jail. We heard some of the pain. Maybe someone in the audience teaches Tai Chi, but our guests don't teach Tai Chi. They jump into and they empower and support those incarcerated to ease their pain and to end it when possible. And we thank them for walking the walk to help the American citizens, and greatly appreciate you educating us today.
Well, and now I'm taking myself off mute because I feel horrible, because I've been saying League of Women Voters, League of Women Voters, League of Women Voters, because that's been my contact point. And there's no world in which the NAACP should be overlooked. So I want to acknowledge that and thank you all, not just for your work here today, but truly the work you have carried and continue to carry in Delaware County and the state and the nation. So
yeah, you stand. Okay, and also just wanted to ask if anyone in the audience wishes to join the league, you're welcome. The League of Women Voters, it's in 51 states and DC, also in Hong Kong and the US Virgin Islands. So, you know, it's a big organization. And also to remind people, tonight at 7 p.m., we will be having a virtual Delaware County Court of Common Pleas candidate forum with the primary candidates. They'll be there to answer questions for the public in a nonpartisan League of Women Voters forum. And also part 2 of the what we're doing here will be post-trial conviction, consequences, and costs. And that will be held Wednesday, June the 16th. And thank you all for attending, and have a wonderful weekend.
Thank you.
Bye.